Viking lawyer's got a brew in hand, streaming wild cases across the land. A courtroom circus, a legal ride, slightly buzzed on justice and a Viking's pride. Objections flying, gales a swing. Nick just laughs, oh, what a thing. It's a slightly buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Mugshots rolling like a movie reel, a pizza thief or a banana peel. He calls it absurd, he calls it wild. Your Honor, is this trial on trial? Raise your glass to the streaming king, a Viking lawyer with a legal zing. Don't sue me for fun, I'm here for the lore, and maybe one more drink before we explore. It's a slightly buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Hear lawyers glare.
Hey folks, it is Saturday, not Friday. Due to a sudden winter storm here, I got some power outs. And so it was postponed from yesterday to today. As you might see on my outfit, we are going to talk about Canton, Massachusetts. Because I heard they love their rubber duckies. And we're going to check out yesterday's hearing. And, oh, wait a minute. Dave, you haven't been on for quite some while. I'm inviting Dave. Dave, check your DM. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. All right. Well, yeah, Amica fan. Yeah, it's Sunday in some parts of the world already. Well, it's Sunday in 2 hours for me. It's Friday adjacent. Oh, exactly. Friday adjacent. Oh, you're jealous of my beer? Oh, this is, I got, this is Church Titan. It's a cooperation between Omnipolo Brewery and Great Divide Brewery. It is an American-style double IPA. It contains barley, wheat, and oat. Then there's a best before date, but I really never have to look at that. Oh, yeah, we all know about timelines. Yeah, yep. But first, I got some packages. So we start with opening and see. Oh, all right. Yeah. And I need a knife to my microphone keeps I brought up the small knife to open the little package. There, let's put the tiny knife over there. Nice, yeah, thank you. All right, it seems like drunk me wants me to have more beanies. All right. Package number 2. Package number. Oh, yeah. Let's open this up carefully. No. All right. What's going on here? Let's go. More beanies. Okay. So I got the same. 2 of the same. Okay. So all right. Let's get a poll. What beanie? Small skull or big grin? Or the one I'm having, let's call that big skull. There. All right. Yeah, it's always good to have a backup. Yeah. Now, do the beanies actually fit your head? Let's just say I'm very glad that I have my headphones keeping this one in place, because having a beanie on my giant head, it ends up with everything being up here. I can make one into a sweater from Mr. Jingles. I could, but I also want to live. What was it? 2 years ago? 3 years, Christmases ago, I put Mr. Jingles in a Christmas outfit. I had to sleep with one eye open for 6 months. All right. In the lead now is Big Skull with the big grin as a close second and Small Skull as a third. But let's keep that. Next is a full pirate costume. I have the hair. proper hat. Proper pirate hat. Yeah. Oh no, you're giving drunk me ideas now again. Yeah. But let's keep that poll. Let's keep the voting going for a bit to see where it ends up. There are currently 30 of you here, and there's not 30 votes. So, you lived to tell the tale. Yes. Yeah. Maybe the cat outfit for when there's a medical reason. Yeah. That won't stop Mr. Jingles from being Mr. Jingles. Oh. Now, let's see. Now, I do have the... Kearney thing up and ready to go, but I did see something on X not that long ago in the Karen Reed case. What was that? Oh yeah, you have the anti-free Karen Reed people going on and on and on and on, being jackoffs. But that's nothing new. They have been there for quite some time. Aw, Dave can't join. Unfortunately, I have to spend today and tomorrow working so I can afford a super chat. Because he won't be able to join me. Oh. Gonna be drunk watching Shmeen later. Yeah. Thanks, Dave. Thank you. Thank you so much. Thank you so much. Oh yeah. I have to show you this. The antis are, yeah. Let's just go through the latest morality, because they really, really don't want Mr. Deitch, Adam Deitch, to become the next prosecutor, the next district attorney in that area. So let's look at the insanity they decided to go with. They said, Josh Levy, U.S. Department of Justice, worked with Adam Deitch on Reed federal investigation, question witnesses based on Aidan Kearney's blogs. You fucking retard. The investigation against the people in the Karen Reed case, the cops, was ongoing before Aidan started to write about it. You barely functioning morons. And then Adam Deitch, U.S. Department of Justice Major Crimes Unit with Ann Peruti. Ann Peruti's husband runs campaign, worked with Josh Levy on Reed federal investigation, question witnesses based on Aidan Kearney's blog. Again, barely functioning retards. Barely functioning retards. And then they go from this up here to Michael Loans, married to Ann Peruti, campaign manager for Adam Deitch. So, Tricia Peruti Dicker, and Peruti's twin sister, classmate of Karen Reed Coyle and Cassidy High School. They are years apart. I believe there's a 4 or 5 year age difference. You retard. And then the Ann Peruti, and then it's all connected to Karen Reed, William Reed's. And here's the thing. You can connect everybody with everything, but as soon, look at this. 1, 2, 3, 4, 5 steps between Josh Levy and Karen Reed. 4 steps between Adam Deitch and Karen Reed. When your conspiracy has to go more than 2 steps, You're a barely functioning retard. Barely. With focus on barely. Now, these idiots let's see here. Who was it? Yeah, this Dick Beck, who of course is that's funny because everybody knew Judge Canoni was pro-defense. Oh, sorry. Here, Dick Beck, or whatever's. Judge Canoni was pro-defense. Seriously? Seriously. You watched that trial? And you thought to yourself, that Judge Canoni, she's very pro-defense. Dick Beck. Does the mental asylum know you escaped? Does the mental asylum knows you escaped? Report to the nearest mental facility immediately. You are not safe out in the real world. You really aren't safe in. Now, some of these barely functioning morons claims to be pro Karen Reed and anti Aidan, but then they post shit like this and they revealed and said, no, it's the same jackoffs that was anti Karen Reed, just with new accounts or renamed accounts, trying to split everything up with stuff more or less. Oh, you can't support Aidan Kearney if you support Karen Reed, and vice versa. You can support both. Why? Well, because both Karen Reed and Aidan Kearney, the government tried to fuck them over, or the local government tried to fuck them over both. I don't give a shit about the drama. I don't give a shit. What matters is the government tried and still tries to put them away. If they found anything, they would use it. They are still trying with Karen Reed with the witness intimidation. No. Just no. It really is that simple. So I don't know. I don't know why there's some differences between Karen Reed and Aidan Kearney at the moment, or if there is. And if it is, it's been blown out of proportion. You can support them both. As you should. All right. Now, what else was the thing I wanted to... Let's see here. There was some filing done. Where did that go? Where did that go? Dun dun dun. It's in the civil suit. Yeah, they what was it? They dismissed voluntarily the subpoena against one of the cops. I mean, it's a civil case. If they believe he has nothing, they have nothing to gain by it, yeah. Or if they think they can get the information from elsewhere, because as I understand, they will get more information from former Trooper Proctor's phone, which means they might not need that junior officer, that information. They already get it. They already get it. All right, let's see here. Voting has been going on for 13 minutes. Oh, Small Skull is catching up with Big Grin, but Big Skull is still in the lead. Let's go for a few more minutes and see what happens, because there are currently 50 people on YouTube's and 30 votes. So 20 of you haven't voted yet. I wouldn't mind if you did. Yeah, the nerdy followers are... Yeah, of course. Both Aidan and Karen have naughty followers. But I do not believe those are the... They are more followers than leaders. And it's quite apparent to me, at least, that the people actively trying to break everything up is the former antis. Might be McAlberts. Yeah. 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 Also, justice for Sandra Birchmore. Yeah, I saw that he tried the most probable killer of Sandra Birchmore tried to get the case dismissed, claiming that, oh, you didn't charge me properly. Yeah, they did. That's going nowhere. That's getting nowhere. All right, folks. Let's see here. We have, yeah. I'm ending the voting now, and third place, Small Skull. Second place, Big Grin. First place, I'm keeping Big Skull. Hey. All right, let's go into the thing I was supposed to do. This is the Aidan Kearney hearing, the full hearing. And thank you to Justice Serve TV for uploading the entirety. Thank you so much. Thank you. All right, I'm going to position myself up here. Let me know if sound is okay. And let's go.
Good morning, Your Honor. Tim Steve Radel on behalf of Aidan Kearney.
Good morning, Mr. Cosgrove. Mr. Riddle.
And for Mr. Kearney, Mark Federer. Good morning, Your Honor.
Good morning, Mr. Federer. Okay, just to be clear, we've accommodated as many people as we can in the audience. I understand there are some folks outside. The court has opened the matter to Zoom, primarily because of the weather and the parking conditions. I'm not going to say that we're going to have it on Zoom every single time, but those
Okay.
who can't be in the courtroom right now,
I'm going down
we are
here.
broadcasting by Zoom. Further note, the court was prepared to come out at 9, but the delay was due to the late arrival of some of the counsel. So with that, I would remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 1119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate. So, with that, my intention today is to cover papers 110, 117 in part, 125, and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the Commonwealth. Now, before we begin that, particularly Mr. Pepper, just to you, I know Judge Newell may have talked to you about this a little bit. Going forward, we don't file affidavits as motions. Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law. It can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for. Further, it has to deal with one subject at a time. We're not going to do motions that deal with the entire kitchen sink. It's going to be one motion at a time. It's going to be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you filed. If you want to put in a supplemental motion or a supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time, which is kind of absurd because I'm trying to trace back what you're talking about and I can't find the motion because it doesn't exist. So I understand you're not local to Massachusetts. Mr. Braden is extremely experienced and quite good at drafting these things. So,
Judge, I was going to say that's my fault. I'm local counsel. I should have made sure that was that way, and we'll make sure of that going forward.
and I know that paper number 127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area. That's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with. Nor do I want to.
Yeah, I can't blame the judge for that. I've loved the mega motions. I have. But if this judge says it's going to happen this way, that's the way it's done. He does say the thing going forward because I believe he also recognizes that other judges don't mind this with the mega motions. Some even prefer it. That way they can handle everything at once. This judge, no. Everything, ding, 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 ding.
Have to hear from Mr. Cosgrove saying there's no motion filed because it's a pretty good point to his part.
So Mr. Cosgrove, if you say there's no motion, you replied to it. You filed a reply to it. That means you acknowledged what was in the mega motion. You're whining. Oh, please, just retire. I mean, jokingly, I with with good luck, I might have 20 years still in me. Cosgrove, that's counting in days.
With that, let's take up the matters that are before them.
And that's not a threat, that's a joke on his age.
Mr. Bradley or Mr. Federal?
Mr. Betterell, Your Honor.
We'll hear from you.
Thank you.
Now, folks, if you haven't seen this, I've seen clips of it. This judge seems to believe he is an appellate judge. It's courtesy in most courts that you allow the motioner to finish. If you are interrupting, not only do you break their flow, but you're interrupting because the answer to what they are saying at this part will come later. But this judge treats this as he's an appellate judge that can interrupt all the damn time.
I understand I've looked at all your motions as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course, but as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from the Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I note that the last docket entry in that case was in the process of being settled. That's paper number 15 in that case. That was filed just last week.
Judge, whether the civil case continues or not isn't even necessarily the issue.
Explain why that would not be a problem.
Because she has accused him, a lawyer, a former judge, of unethical behavior, and he has a personal interest, understandably so, in defending himself against that. And in any matter in which her credibility becomes an issue as she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is, calling her an alleged victim and that there is a conflict because of her allegations against me, merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied that, well, we're not going to call Ms. Gaetani as a witness, and that certainly is right for the time being anyway as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be an issue, obviously, if she testifies in this case. At that point, having a prosecutor who has been accused of misconduct, who is named as a civil defendant, attacking her credibility and attempting to defend the credibility of other witnesses whose credibility could be impeached by Ms. Gaetani is a problem. It's a problem because the jury would have a right to know what the prosecutor's interests may be. It's not.
What if you chose not to cross-examine?
That's a decision that has to be made by a disinterested prosecutor.
What if you got someone else to cross-examine?
That may or may not solve the problem. Certainly, it
Oh. So this judge is suggesting that it will be handled as in the Zachariah Anderson case, that suddenly the lead prosecutor has to just step outside for a minute during cross-examination, as if that changes anything. The state is the state is the state is the state. Doesn't really matter if there is, say it was a police officer. Would that police officer be allowed to testify as a rebuttal witness against Ms. Gaetani? No, because they are in civil litigation. So why would a prosecutor in civil litigation with a woman accusing him of unethical, immoral, despicable behavior be allowed as a prosecutor in a case where she is either a prosecution's or defense witness? It doesn't make sense. this is, and we see it sometimes. When it's between cops, it's called the thin blue line. Here, it's the thin judicial line, where judges protect judges. Sadly, that's the thing. Judges protect judges in this misdirected, well-meaning argument that we have to protect the integrity of the judicial system. Yeah, but I understand the argument. It's just it's misdirected. Protecting the system is done by throwing out the bad apples.
With the direct examination of her,
Well, he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you, right?
Yeah, all of a sudden, Cosgrove says, "Oh, I'm not going to call her." Didn't you use her in the grand jury? Didn't they? Didn't they use her to get this indictment from the grand jury? But all of a sudden, she's not necessary. Well, here's the thing. If a witness between grand jury and trial is deemed not necessary, so is the foundations of the grand jury indictment. Throw it out.
Right now, respectfully, why it may be relevant beyond just the substance of her testimony. Mr. Cosgrove addressed the substance of her testimony as it relates to the allegations against Mr. Kearney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your materials, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023.
Mhm.
It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Amongst other times, yes.
Around that time, is my understanding, based on the evidence you presented me, around that time, Ms. McCabe urges her to go to the grand jury, do the right thing, go to the grand jury, something along those lines. Right? Is that correct?
In substance, but I think it's interpretational and the witness might expand it.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact.
Bias after the fact is still bias. It's still bias, Judge. It's still bias. If Ms. Gaetani can testify that Jen McCabe is a lying liar who lies, then that's relevant for the jury to decide the credibility of Jen McCabe.
This is after the fact bias.
Yes.
On an issue
Real
which,
bias.
frankly, I'm struggling with a little bit because nobody contests the acts here. All right. Mr. Kearney is a citizen journalist, sort of a new breed of journalism.
Give credit where credit is due. He's a citizen journalist. Journalist. He reports on stories to a greater audience, making him a reporter protected under the fucking First Amendment.
Correct. He presents to this court that all of his activities are fully protected under the First Amendment. It's a very reasonable argument. Okay. Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential by and large, is it not?
Judge,
I know she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked. But that's not what this trial's about. This trial's about what happened 6 months before. So you got to draw me to the relevant.
What happened 6 months after is related to what because remember, Judge, Jen McCabe didn't claim to be intimidated until way later as well. Until she was speculatively, she wasn't claiming to be intimidated until she realized, by others, even Miss Gaetani, I can set Aidan up.
Of that.
Her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover, it's
But it's all after.
It's not
before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated or I was emotionally harmed. I think we would all agree that would be relevant about what the impact that these horrible allegations had on her. There will be evidence through electronic communications between Gaetani and McCabe, which Gaetani may very well have to authenticate as a witness. Because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also corroborate.
The intimidation doesn't have to last forever. The intimidation, we're only trying one slice at a time. That's the bedrock of any criminal defendant,
Of course,
right? We're not trying his entire life, we're trying that moment.
but these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastic, as I understand.
I believe so, Judge. No question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
What is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I have no determination as to whether I'm going to call Tully or whether I'll need to call Tully.
Cosgrove here is I don't know if I'm going to call this or that witness or whatever. Cosgrove here is evading. He may not call Tully. He says he will not call Gaetani. Who is he going to call? Ghostbusters? Seriously. This evading, it's either a yes or a no. But he evades because if he says no, then he will give a weapon to the defense. If he says yes, he will give a weapon to the defense. So he's evading to answer in order to stall.
To me that the videos which Mr. Kearney has himself made public documents his statements and actions that pretty much self-authenticate. I'm not sure.
Well, I think you may have to make a choice here fairly quick if we're going to deal with this issue. But continue. Right?
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
This is not your classic whodunit.
No.
This is not the investigation where they find evidence on the scene, they develop the evidence on the scene, they trace the suspects, they get phone downloads, they do this, that, the other. This is a very unique set of facts.
Very.
Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large. So the investigation essentially is press record, and then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
The point I'm making, Your Honor, is that Tully...
And I would like the jury of his peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
The point I'm making, Your Honor, is on this issue, is that Tully is the lead investigator. And certainly I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call.
I don't find that to be accurate in my experience.
I've
seen it happen a number of times.
I've seen it happen.
Much to my disappointment when I sat over there. Okay?
I've seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting juries know who built the case, what is going on here. But the point...
And fairly pointed out by the defense, and you didn't hear from it.
It could be. It may very well be, but that could also lead to the reason why. Okay? The issues surrounding Gaetani's claims, that the defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know why isn't the prosecutor calling him, and might it have something to do with what Gaetani alleges. But moving away from Tully to the larger point, it's not even so much the cross-examinations, or other evidence, which I would suggest are improper, being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. If Mr. Cosgrove has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the personal interest. It is, anybody can bring a lawsuit against anybody, right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them apparently, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable. Correct?
In a legal sense.
Sir, this is a legal.
No, Judge. Oh, I understand the judge's interpretation here, but he still has to defend himself against the allegations. And the allegations, regardless of immunity, has relevance to the case, this case, him as a prosecutor. It doesn't have to be, it doesn't even have to be a civil suit. It's the appearance of improper, which could and should get Cosgrove disqualified. Now, the civil suit against him helps, but it's still there. The allegation in itself is valid for this court and this case.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. With this lawsuit that we're saying has no merit, what did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure that's what he said, but
He recused himself, acknowledging to court that there was an issue that prohibited him from cross-examining, and that is why he's removing him from the case. Now, this case here is it's the same but still separate. It's the same but still separate. Speaking of the same but separate, we have Aussie Overlord.
Good morning. How are we? Or good afternoon, I should say for you.
Oh, yeah, well, good evening from here. Good evening from here. How are you doing?
I honestly can't complain. If I do, I may be arrested. So,
Yeah. We are headed the same way over here in Europe.
Yikes, isn't it? It's just absolutely batshit crazy. But anyway, I was keeping track. So apparently, this judge decided it'd be a good idea to switch to the inquisitorial system for this trial, or what?
Well, it seems that this judge has a slightly different opinion than other judges. Oh, echo. Was there an echo, or was that just me?
Wasn't anything on my end, I don't believe.
Oh, okay. Yeah, this judge is making a thing about the allegation from Jen McCabe that she was so scared of Aidan happened 6 months before this event that they are bringing up with Lindsay Gaetani, Jen McCabe, and others conspiring together to get Aidan rearrested. While other courts have said, yeah, that kind of has merit. But this judge, but it's by after the fact bias. And I'm over here like that, but that's still bias. I don't give a
Yeah.
shit when it happened. It's still bias. And they're not blaming Jan McCabe, not blaming Lindsay Gaetani. They're saying Cosgrove already recused himself from other cases for the same reason. Why does he cling on like a two-dime Polish hooker?
Well, that's not the hooker. That's the crabs that are hanging on.
Oh yeah. Involuntary hanging on. Second hand. All right, here we go. Oh yeah, so this judge he treats his court like it's an appellate court. He interrupts Mr. Bedrow all the time, not allowing him to finish the sentence. And then I'm saying this, and here's the evidence for it. Here's the conclusion. He just yeah, and interrupted. And I'm used to seeing that in appeals court.
Mhm.
This is not appeals court. This is court.
No, it's generally like it's more of a convention than a rule, but it's
Mm.
professional courtesy to allow someone to finish making their motions, and then you
Mm.
give commentary. You save your questions.
Mm.
It's almost like high school debate sort of thing. You at least
Yeah.
allow the person to finish their arguments, and then
Mm.
if you can tear it apart, you do so. But I mean,
Yeah.
generally, if you're a judge, you're going to at least sit back and take notes.
Yeah.
But it's. I mean, look,
Yeah.
it's,
Exactly. It's like, here's the one party. Okay, thank you. I'll listen to you. What's your counter? But here it seems like the judge. No, I'm going to counter, as if it is appeals court,
Mhm.
and I'm not used to that. And this thing with after the fact bias. Well, it's still fucking bias.
It
I
still
don't get it.
potentially affected the case. It shouldn't matter if it was proven after the fact or not. It's
Yeah,
yeah.
and it's yeah. So we are like 20 minutes into Bedrow's argument. He would have been done by now
Mhm.
with his entire argument to the court, but oh yeah, and he judge complained about the mega motion. He wants everything one issue, one motion, one issue, one motion, one issue, one motion, instead of having everything for the totality of the circumstances, which usually is a prosecution's thing.
Yeah, it's usually the way they go about it so that they can, if necessary, conflate certain issues.
Yeah.
Wow, okay, so this guy's taken the whole "it's my courtroom, my fiefdom" to a
Yeah. Oh, and by the way, this is the judge who took the seat after Cosgrove retired as a judge.
oh,
I
great.
don't know if they know each other.
Mhm.
But I mean, in the United States and everywhere else, if judges are friends, personal friends, why are you there?
Yeah, I mean,
Yeah, but
there's a particular reason. For example, here we rotate our cops around so that they don't
Mm.
actually they don't patrol, for example, in the areas
Mm.
where they live.
exactly.
So,
Yeah, we have that over here as well. Our cops get appointed.
Mhm.
You're going over there, and rookie cops often are forced to go to remote places, and they are so happy about it. You know what? Arctic Circle. Yeah, I'm going to have to move my entire family to bumfuck cold ice bear country. No. Yep.
Could
But
be
then
worse.
again-
It could be the rookie assigned to guard that bottle of whiskey that people keep fighting over in the middle of the Northern Hemisphere.
There are rumors that neighbors up there, we are talking about, oh, he's just an hour away. And there are rumors that they are very, very friendly with cops to Don't mind us hunting. Yeah, so no, if you're for instance, where I grew up, we had one police station for an area roughly the size of Long Island, or well, I don't know, big, and it was only open office hours. That's how remote we were.
Jeez.
And the rest of the time we have to call either from the nearest city, which was hour away,
Mhm.
or 2 hours away. So it was never anything. Can we handle it ourselves tomorrow? Hey, Hank in the corner is driving drunk again. Yeah, okay. No, folks, don't go on the road. Hank is on the road again. Let's
Just call
visit him
around and say-
tomorrow, or take impound his car when he crashes. Don't call the cops. Just
It's easy just to take his keys.
yeah, it takes longer for the cops to come over there than for him to sober up. So once they are here, he's sober.
Well, imagine them trying to get evidence that he'd actually driven, aside from the fact that the car might be plowed into a tree.
Yeah. At that time, he's back home and saying,
Exactly.
"No, I
I
didn't
wasn't
start
driving. Prove it."
Yeah, I didn't start drinking until I got home. A deer ran over the road." I mean,
Oh. I mean, it's not like we can talk. We had a guy lost his license the other day for letting his dog drive his car.
oh.
People on the beach were not happy.
Nope. Our local cop, he lived not that far off. After the neighborhood party once a year,
Mhm.
His kids drove him home in the snowmobile, in the snowmobile sled. They were 5 and 7. So, Nick, you drove a little bit fast here. Aren't you the cop whose kids drove him up? Just a warning for this time. Oh, really? A cat man gifted 10 memberships. Thank you. Went to JKD Buck, Anova, Lady Gnome, Lady Star, Melanie Waters, Kay Young, Amber Dawn them Johnsons, Freedom Lover, Tommy, Rosie B. And that, folks, actually gets us to, I haven't even, oh, Jesus. Gets us to the first spin on the Wheel of Regrets.
Hey, there we go.
Here we, oh, shit. Oh. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. Hold on. I don't want any hot sauce today. There.
All right,
I'm really not a fan of Malort either, but yeah.
How did you find that? Did you pick that up and take it back with you, or did you have to get it shipped?
No, they actually manufacture the thing here in Sweden. At
No way.
Barsebäck's Brandery, which is like an hour away from me. But here, this thing is rigged. I mean, this thing is so rigged. I mean, for instance, look at that tequila. It's still half full. Look at the Malort. It's like this thing is rigged.
Well, it knows what will bring you the most regret.
All right. Spinning the wheel of regret. Yeah. Bonneville Bourbon.
Bourbon.
Bonneville Bourbon. Dun dun dun.
I would join you, but it's still like 9 a.m. So
Yeah, it's 11 p.m. here. So let's see which Texas shot glass.
nice.
Come and take it. Yes, folks, this is slightly burst. Well, Saturday show. It might, if you're generous, become slightly slushed Saturday show. Cheers.
You heard the man, people.
Ah. Ooh. This is such a nice. This is Bonneville Bourbon, 46%. Jesus. Which is 92% proof. Out of Salt Flats, Salt Lake City. All right. Should we continue watching the Aidan Kearney hearing?
Yeah, absolutely.
Yeah.
I think that's
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or a party, and we talked about whether we use alleged victim or witness as the issue. The point is,
that's what I said. That's not exactly what he said. What he said was,
yes, I'm not trying to substitute that. We're trying to, in my view, suggest that's a distinction without a difference, because he has been attacked. And when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
I take your point. Mr. Cosgrove, you're ethically precluded from one, why aren't you ethically precluded from two? I'll come back to this issue of the 2025 investigation too.
I reserve my answer.
Please, Judge, let me think about it. I'll reserve my answer. Stalling?
Yeah. Generally, the judge goes, "No, you answer me now."
Yeah, generally.
Reserve it for when?
Oh,
Reserve it for when. There we go. Okay.
I was about to give you your turn to speak. Go ahead, Mr. Vedero. Let's talk about the 2025 investigation.
Can I, Your Honor, can I make one point I didn't get to? We kind of got. It's the summations where the real problem arises. Because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost.
well, am I buffering? 3? Folks.
I think maybe they were saying that he was buffering with his.
Oh, yeah. Cosgrove is buffering. Yeah, okay.
Free deposition. It is sworn testimony of her by a litigant against another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to summations. Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth, it is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt Jen McCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility, is discrediting her, crediting another, and it's tantamount to him giving unsworn
This
testimony.
goes back to the issue of relevance we talked about before, and this is where I'm a little bit hung up. What McCabe does, 6, 8, 10 months after the allegations here, the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Kearney before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine. No doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right, she's the star witness of this case.
I mean, it didn't need know a little bit more about that. In terms of, if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who
Yeah,
shares
say
what
that.
and those kinds of things. It's critical for us to make this record now, alert the court respectfully,
No issue with you
and
making.
because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault. And we think at that point,
Listen, Ms. Better, I have no issue with you bringing the motion. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand
Understood,
exactly
Your
what the
Honor.
issues are. You know, I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better, because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant. And we'd have to sort of play out how that would come in and what that.
Yeah, but he already told you that. Gaetani can testify to things that happened closer in time, speaking to a pattern of Jen McCabe, of actually not being afraid at all.
Mm.
But yeah. Now, this judge has gotten a lot of crap. A lot of crap. To me, he is either playing or he really is ignorant to most of the fact of all the cases.
I was going to say, he seems like he's doing a lot of mental gymnastics here to play that he's not understanding why this would be relevant. I mean,
Yeah.
most judges would err on the side of caution here and say, okay, there's a potential issue here. This could lead to a mistrial. It's no skin off anybody's nose if we
Yeah.
replace the prosecutor. It's like,
Yeah, and it's, I mean, there's apparently plenty of time to trial. Cosgrove has already recused himself of the other things. Write an off I fuck motion and off you fuck.
exactly.
It really isn't that big, because in theory, at least, the facts of the case are still there. It shouldn't matter who's the prosecutor. Now, we all know that's bullshit, but in theory, at least.
Hmm.
Because there's a reason why they called in a special prosecutor, because nobody wants to touch the damn thing. It's like with Brennan, special prosecutor in the Karen Reed retrial. Nobody wanted this. Not one. So they had to pay this guy $500,000 to do worse than the first prosecutor. At least Lally had one who was, maybe. Brennan had nobody.
Before that happens, so we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had 3 parts. Your affidavit had 3 parts. One was the 2024. That's moot because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in the search warrants for the phones of Karen Reed.
Which is still pending with Judge Crump.
Right. That search warrant.
Let me play that out 2 ways. What if Judge Crump says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that 2 people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and the grand jury said no. And now 2 years later with phones that have been gathering dust, we need to look at these phones and, God knows what we'll find. But the point is the search warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are 2 informants in that search warrant. One of them is Lindsay Gaetani. And the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number, relying on her, and it is loaded with information which she provided them. And we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you that it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Crump has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no settlement.
I looked at the docket this morning.
Not with him. That's with other parties to the litigation. It's my understanding.
Well, let me play this up for you. It's, as I said, I have some familiarity with this since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, an accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually.
Yeah, but still, as I said earlier, the accusation in itself is a problem for the prosecutor. Even though he has immunity, it still gives the appearance of bias from the prosecutor. So I don't see how that is relevant if he's getting off the hook because of immunity reasons.
No, because it still would have the implication for the jury. It still has the bias and it could still affect the outcome. So,
yeah.
Just because someone does the job and... I mean, okay, let's use an extreme example. Cop has qualified immunity. Cop shoots somebody. People still get pissed off at the cop even if they can't be sued.
Yeah. And if that cop then shows up and testifies, something, that might not, No, I almost made a bad example there. Because cops do it all the time. Yeah.
Yeah, no, I feel like he's doing a bit of mental gymnastics here to try and make it more difficult for them, frankly.
Yeah.
Disqualified, but I'll keep an open mind on it.
Does anyone have anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Brady, anything more?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosmo, if not, if you're conflicted on one case, why are you conflicted on the other? That's the real big question.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Kearney was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case, that Mr. Kearney committed crimes against Ms. Kearney. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Kearney's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if you came to trial?
Well,
He's not
that's
going to answer that legitimately.
a very interesting point.
Sorry, what?
There's no way in hell he's going to answer that question legitimately in open court. Is the judge serious right now? No lawyer in their right mind is going to stand in front of a judge and say, well, it would personally benefit me to discredit this witness during this trial.
Yeah, oof. Welcome to the madness.
I missed this.
There's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Kearney was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives the motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any actual dispute. I'm sorry, Worcester, yes, thank you, I appreciate the correction. I don't think there's any factual dispute as to what happened. In my capacity as a prosecutor, I provided Mr. Bradel with the police report in question as discovery. It made its way by whatever means from Mr. Bradel to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I can possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter.
How do we avoid the circumstance that she's called us, and there's some relevant testimony that she not you would call her, but the defense calls her, and you're in the midst of cross-examining, and she says, "Well, this is why I sued you." What do we do with that?
Yeah,
It's a damn good question.
yeah. What, Mr. Cosgrove? Defense puts her on the stand, and you cross-examine her, and she says, "Well, that's why I sued you." What do you do then? Now, at least the judge is consistent.
Hmm. I will give him that in relation
Yeah.
to this, 'cause that's
Yeah, but I can't say that I agree with this approach because he's not an appellate judge.
but at least he's being a dick all round. You're right.
Mm. And I really, really like this question. Yeah, what, Mr. Costco, what would you do?
I'm not sure what you do.
Not really the right answer there. He had a 1 in 400 chance of getting the right answer, and he did not get it.
And he's supposed to get the right answer, and he says, "I don't know." Here's an idea, Mr. Cosgrove. If you don't know what to do, you shouldn't be there.
See, and really what that does is sort of highlight the fact that there is an ethical conflict.
Yeah.
Because if you can be put into that situation, you should have removed yourself. It's really
Yeah.
that straightforward.
And here's the interesting part. Even if another prosecutor goes up and cross-examines her, and she says, "Well, that's why I sued the previous prosecutor, Mr. Cosgrove." Okay. Then what? It still rolls back to the appearance of impropriety from the prosecution.
Maybe we deal with that with the motion of limine to preclude her from mentioning the substance.
That's not entirely controllable.
That's why we have skillful Superior Court judges, Your Honor, if I could be a little obviously self-serving in my comments. I'm sure Your Honor told his prior career, as I have in mind, and your present position has dealt with the witnesses that are difficult to control.
His answer to that was to preclude her from testifying about the court case.
Right. So, which would be from precluding the defense from attacking the witness or not for attacking McCabe. Speaking of
This
attacking
stinks.
McCabe, we have an Aussie horde incoming.
Hello. I
Hey.
better not say anything to insult my fellow Australian, because if he gets his feelings hurt, I could go to prison for 5 years.
Oh, tell me about it. It's ridiculous, isn't it?
It's fucking stupid, man.
Oh, wait, you have to be nice against each other.
We have to.
Yeah. Oh, wait,
But-
no. Oh, I was going to say something that could have got me in a lot of trouble. And I'm going to stop.
It
Hello?
doesn't matter. It doesn't even
Hello?
Let's say
matter.
we're both of the demographic that can still be discriminated against without any issue.
No,
we
no,
can't
we're
discriminate
fine,
against
'cause,
anybody
like-
else.
But we can't even
But-
say what that demographic is, because other
Exactly.
people get their feelings hurt. And if other people get their feelings hurt, then we could go to prison.
Okay, Hella and Hayden, what do you think about indigenous people being positively discriminated? Yeah. Sa- sa-
I can't, because I can't even cop an allegation.
Sadly, folks, this is a real issue in Australia. This is an absolute real issue. Folks, protect your First Amendment with everything you got, or you will end up like Australia, or
Mhm.
as over here in Sweden, it is illegal for me to call a cop a pig.
We can still do that, can't we?
No, someone actually got pinged for it about 2 weeks ago. They called a
That's right.
protester a pig.
That's right.
Yeah. So, folks, from 3 non-Americans, protect your First Amendment with everything you got, because once it's gone, it will never come back. And you will be where we are now. I cannot insult a government employee. That means cops, teachers, which understandable, sort of. Political secretary, political expert. They are government employees. I can't tell a current person of the government's political expert to fuck off, you retard. Protect your First Amendment.
I've got people in my chat, in my comments right now, like when I say, "Oh, we don't have a First Amendment, we don't have free speech," and people get in my comments, Australians going, "Don't say that, we have free speech." So I'm like,
No, we don't.
No.
As it is, they're looking to undermine the political free speech that's implied.
Yeah.
implied.
Yes,
Yeah.
we can. This is an exception. We can insult the Swedish royals, since they themselves are exempt from any law. They are above the law. The Swedish royals. They could murder people, and there's no way to charge them. Yeah. Ta-da! Isn't that? And also, there are, I know Aidan comes across as an asshole. I've told him that himself on numerous occasions. That's exactly who needs the First Amendment protection.
I can insult Dali.
Yeah, but he likes it.
Okay, but that's why people ask me why I only cover American stuff. Is because I'm scared I'm scared to comment on anything in my homeland.
Yeah,
it's very
it's a legitimate problem. There's a reason. Like, you came to me a couple of years ago asking whether or not I'd comment on a particular case, and I mean, even at that time, the courts had standing orders saying, no, you can't publish anything on YouTube, even if we stream it. And I was, because I actually applied to one of the courts, and at that time, another streamer just happened to stream it as well, and he got pulled in for contempt of court.
He did.
So,
he did. He got pulled into court. He did. And yeah, there's been one since the mushroom case, and that there's been several people who have been threatened with contempt of court. I don't know whether they actually got done for it. But,
not 100% sure, but yeah, it's been quite ridiculous. And just for people to understand how insane the new hate speech laws are, I can see people asking what would happen if we were to insult someone from America or anyone else. We don't actually even have to actually offend someone. It's whether or not the court would decide that a reasonable person of that demographic may be offended or insulted.
Yeah. Protect you. And I'm covering currently somewhat the a dismember murder performed by a person now known as Wilma Anderson, and who is, but legally, a woman. I have to be really really careful with how I address. By the way, this is Wilma. Of course, it's a woman.
Of course.
It's legally a woman. It doesn't matter that she dismembered and is a prime suspect in other murders, making her a possible serial killer. I still have to address everything about this as a person now known as Wilma, and legally she is a woman. She has no surgery. She's legally a woman.
See, Nick's just baiting us now because we're not allowed to comment on that.
Yeah.
We can. Okay. So here's the deal. We can comment on stuff as long as it's stuff overseas. Because the person overseas, we're not committing the act overseas. Please tell me I'm right.
No, you're not. That's the problem. Because
I can't comment on anything.
No, it's quite literally someone here can be offended on other people's behalf, and they can be the ones to make the complaint and report us.
Yeah. Yeah, it's the same thing here. If I were to go out on the street and say, you know, that teacher who allegedly was too comfortable with kids, that's a piece of shit.
Okay.
Then somebody else takes offense on that teacher's behalf. I'm fucked. Protect your First Amendment, folks. For the love of everything, protect it.
Yeah, there's a good lawyer who's breaking all this shit down. I've been following. He hasn't said that bit.
Really?
Yeah, I can send you the link. He's doing a really good job. But it's minority groups, right?
Yeah.
So I can have someone insulted. I can insult people for weaponizing the law.
You can insult Hayden all you want.
Yes, we can insult each other all we want.
Yes. I can insult white people, right?
Yes.
Yeah.
Okay.
Because technically, under the laws, we're not considered a race.
That's correct. So Sally, suck shit.
Yeah, and even though I can trace my family to before there was actually writing, I'm not an indigenous person. Even though my family traces back 1,000 years. Yeah.
Sally's autistic.
So, to the question which shows up every now and then, you're not American, why do you care? Because we're not allowed to care about things that happens back here.
That's basically what it boils down to, people. I've already organized for my wife and daughter to arrange their passports because I fully expect a knock on the door at some point in the next year or so.
Yeah, and folks, it would help if you subscribe to these two wonderful persons, and if you're not subscribed to me, do it. I've calculated my retirement to the United States because in order for me to retire over there, I have to turn down the government pension, which is in American dollars, $3,000 a month. I have to throw that away in order to retire to the United States. So around 1.6 million American dollars, which would get me somewhere to live, broadband connection, and then I can at least still do this while retired in the United States. And I found some plots of land in Tennessee and stuff like that. That almost reminds me of home.
I was going to say 1.3, that'd buy a hell of a trailer.
Yeah. Yeah, but I still have to have an earning of sorts. because with 1.6 and 5% dividends, that's 80,000 a month or a year. Yeah. And then I have to pay taxes and taxes and taxes and taxes and taxes and taxes.
What
And
was that
speaking
scene
of
from that John
things you
Goodman movie,
really don't
Bruce?
want to do, no, he disappeared. That was such a great Passover, and then he fucked off. Danny, come back! Oh.
I need to confirm he's all right with me insulting him, but it doesn't matter if people are offended on his behalf.
Hey,
Speaking of offended, here's Dolly.
very
Hello,
offensive.
hello, new cat.
Cat. Welcome, Dolly and his pussy. And
Yes. He's one of the
oh,
more behaved ones of the three.
there's such a thing. Have you met Laura Owens?
Hey, she's just down the street from me.
Yeah, she is in Arizona. She's
Yeah.
like an hour away from you.
No,
Did you hear
like
that?
20 minutes.
Oh,
He's
Ron
checked.
Owens' bankruptcy filing dismissed. They might lose the house, which
Aw.
also means that Laura might lose her place of living.
I do have a guest room.
Yeah, which is quite funny because part of her bond is having some place to stay.
I could do the funniest thing.
Do it.
Do it! Do it! Oh,
This would be
All
so
right.
great. So great for your channel. Please
It
do
would,
it.
right?
Please do
oh.
it.
What?
Have you ever watched Web Sleuths?
Oh, yeah. I kind of. God damn it.
She's got this chick called Stacy, and Stacy is the executive producer. She's got this highly filtered
Oh, all right.
avatar.
Oh, yeah. I probably should change that.
But, okay. So, Dali, do you know you're actually, at least here, you're a minority. You're the only
am.
American.
Mm.
Yay! I'm special.
Well, yes.
And
That's one of my favorite insults on the idiots on X. Yes, you're special, but your mother didn't mean the good kind of special.
Mm.
Oh, all right. We still have so now. I know that Aidan Kearney is not everybody's cup of tea. What we are,
Including Karen Reeds at the moment.
yeah, but he's still being railroaded by the government. So let's focus on that. And so that is what we are watching and talking about out of that point of view. I know. I've said it before. I'll say it again. I've said it to his face. Well, not his face. We were on stream at the time, but sort of. Yeah, he's kind of an asshole.
Speaking of being railroaded, did you see the woman in Simpsons Court having sex
What?
wait, what?
on Zoom?
What?
She didn't show anything.
Oh, hang on.
When was that?
Friday, I believe. Or
Friday.
Thursday. I can send you the link.
That would save me some time.
Simpson tells her she has to come in so he can make sure she's not having sex in court.
This
I mean,
video may be inappropriate for some users.
It
Well,
doesn't
was-
show anything.
Was it the landlord court on Friday?
Simpson took that stream down right away, but
Okay, that's why.
You've got it
okay.
though, right?
of course.
Of course you've got it.
But
Okay.
some clip channels got it too.
Yeah.
I love the way you do that.
Let's
That
get
was
through
amazing.
this and let's
Look at him! Look how happy he is.
let's
Look
tell
at
the
him.
audience here that let's get through the Aidan Kearney fuck over, and we will get to Dolly's fuck over.
Thank you, Dolly. Appreciate that. She's just popping in and out of the camera.
The camera keeps like jiggling. And at one point, she has a cigarette.
Really need to see
Oh,
this.
and here I wasn't sure what I'd make a video on later.
Oh, Matthew Felty, before you stop back, can you give us an information on your duck jacket? Yeah, people in Canton, Mass, don't like rubber ducks. What is his name? Sergeant Buchanan spent 90 days investigating a person who dropped off rubber duckies in Canton, Mass with Tell the Truth. 90 days full time plus overtime investigating that, brought it to a judge who looked at the case and said, fuck off. This is freedom of expression. Because Canton, Mass. So that is why I'm wearing rubber ducky jacket. Every time I handle the Karen Reed or Aidan Kearney, anything with Canton, Mass, rubber ducky jacket.
All right, I could just tell when Hella started watching the video.
We're allowed to play this?
I sure hope so, because I did. I was watching it live when it happened.
Yeah, and in order to keep...
with the nose. She's wearing it.
I haven't watched it yet.
Oh my god, this is so great, Nick. This is so great. You just have to play it. Oh my god, this is so great. For
Yeah,
chat, this
but
is so
I'm
popular.
going, in order to keep people here, because we still have to watch the
Okay.
finale of this with Mr. Cosgrove here.
Sorry.
I made a joke earlier. I look at maybe 20 years, if I'm lucky, left of my life. Cosgrove has this look of him that says days.
I'll be gone Tuesday.
So let's check this out, and then we will go over to
Wow.
4x speed.
What about the possibility of someone experiencing? Is that something that's realistic?
I didn't quite hear you. Something
What
else.
about the possibility of bringing someone in to deal with this guy Tano if he needs his ways?
Could be done.
Well, it would solve a lot of issues. Fairness, Federal? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with that Tano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani. But if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard pressed to figure out why the issue of the lawsuit would come out.
It could. Again, I don't know.
But that is my job to control what comes out. But so
Yes.
legally, this is about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think no.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure out. I guess the first question is, why are we having this conversation? Why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we have this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove
I
has
think he's
done
not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
So It would appear to me what you're saying to me is, if there was a replacement for that issue, that would be solved.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms.
I
Gaetani.
agree with you. That's
Yeah, but Mr. Cosgrove is the only prosecutor in this case. They have to find somebody who is prepared to take this clusterfuck to trial. And he's paid to do it. I mean, they can call Brennan again. I'm sure. I don't know if that would help.
I mean,
does happen in trial.
technically he didn't lose the first trial, so I guess he
Well-
technically did. They just didn't pull the jury. Never mind.
Not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant. They have to be a witness. I mean, these kinds of things can happen all the time.
You find ways around.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem, just
on this issue, we're not going to hijack the rest of the argument.
okay,
Just
I'll
on the issue
hold
of replacement.
I had a brief response.
Yeah, but he's not done. You're going to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I have yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court to either come in or be relevant in the Middlesex case or assist me in any way. I'm going to go over to Middlesex Superior Court, and frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just nothing to be any.
Again, it has to do with the appearance. Not that it should, would, and could. The appearance.
Lead through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that even the Commonwealth of Defense is going to call her in this case. Mr. Counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears to have effectively done that, but let me make a more motion on the record.
Any objection?
No purpose.
I agree. I would like to take those into judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from a typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about, the Middlesex case has come about. What is it that enables Ms. Gaetani to make the claim that she's seeking to make against me in the Middlesex case? It's that the defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created.
Mr. Cosgrove, you handed it over without asking the court to seal it. You know what happens then, Mr. Cosgrove? It's public.
And why does his head look like he's wearing a very bad bald wig?
Because he can't let it go and just shave what little hair he has. He keeps
Yeah.
reminding me of that actor. I'm trying to think I keep seeing him as the dad from Orville, but I know that no one's going to get that reference.
Wait a minute. The dad from Everybody Loves Raymond.
Different
Oh,
guy,
yeah.
but that works just as well.
Yeah.
Okay.
Yeah, he does look like Frank.
The harm that Ms. Gattani alleges accrued to her from that publication. In other words, if we're applying but-for causation to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding,
Yeah,
no
please
harm
do.
whatsoever to Ms. Gattani with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been a but-for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the
You fucked up. Aidan published it. Aidan made some money out of it. That's not an argument. You still fucked up.
opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's third reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some.
One other thing. Why is Cosgrove replying and not another person on his behalf? That I've seen this done a few times in trials I've covered. They don't speak in their own interest. They got some other person there, a co-conspirator, no, a co-pros, second chair prosecutor, co-conspirator talks on your behalf.
Oops.
It seems like nobody wants to talk on his behalf.
But would you? I mean, this guy is a
No.
flaming ethical garbage bin.
No, I would stay. I don't think they could pay me to embarrass myself to
They could
talk
offer
on
me a
his
green
behalf.
card, and I wouldn't represent this guy.
No. 1.6, no. 3.2, no. I mean, I say this once in a while on my streams that I do this mainly because of the fun, because I sure as hell doesn't make any money from it. But if I wanted to make money, I would just work more. I'm doing this because I'm having fun doing it with friends that I like, and
Dolly.
and Dolly. And yes, you guys sponsor me enough that it covers the cost of running this channel. I get enough surplus so I can have a vacation to the United States or Canada. And I'm deeply, deeply grateful for it. But I
Speaking
sure
of,
as
he's
hell.
way too sober to have to sit through this shit, people. We need another spin on the wheel.
Yeah, I need more super chats. I'm making sense.
Detail, take the opportunity to reply to some of his.
It doesn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant in that witness is gone. That's dismissed. So I don't really know that that's all that relevant. Mr. Federer didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. Just raise the issues I thought would be helpful for the court.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the, I'm sorry for interrupting you, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, we're dealing with discovery right now.
I'm talking about the motion that's captioned, "Sir, reply in support of motion to disqualify Robert Cosgrove."
Paper 127.
I don't know, to be honest with you.
That's 127.
Okay.
Okay, go on here.
I'm playing in
So,
1.5, by the
um,
way, so we can get to schmexy
The
time on
defense
Judge
begins
Simpson's
by
court.
complaining that my response envisions my conflict in a vacuum, and that it
1.5 speed limit
ignores
is still taking forever
the
to say
whole,
nothing.
The whole
Yeah.
context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is
Yeah, because
on
if you're
page 1 of that
disqualified,
motion,
nobody
the
else wants to
suggestion
take the
that Mr.
case.
Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but
Wow.
Damn, there you go.
Damn. Thank you, mispronounced name. Thank you so much. I should have wrote $101 to the next spin. No. I'm joking. I'm kidding. I'm very, very, very grateful. Thank you so much. But all right. It's the wheel of regrets. Oh, for the love of fuck.
Yes. You know, Nick, that bottle's like pretty much empty. Just
Yeah,
saying.
folks. This is what I have left. Because every damn Friday, my slightly burst, it ends up on my lord. I mean, I have bottles here that are all here. Look, this is Firewise vodka. This is how much it's left of it.
Wow. When I just did the $10 bottle of vodka, but I drank so much of it that was all I could afford.
Yeah, you would have gone through 2 of them a night.
No, I got the almost 2-liter one.
Now, folks,
Lasted me 2 days.
Yeah, what will take its place? What will take my lord's place? It is Canadian whiskey.
Ooh.
And you know it's proper because it is a plastic bottle with a screw cork.
No, that's classy liquor.
So this, and I had Ian came on last week and said what he thought about it, and he said, well, it ass. Well, his summary of this is what it is. So this will now take the place of my lord. It is J.P. Wise's aged 10 years. A smooth, bold, and complex rye whiskey. Bottled in Finland or Canada. I'm not, yeah. Okay, so this will take the place of the Malort. As you can see, it's not opened. For this time, unless you pay me for it, this is the final Malort. Oh, thank
It's
God
funny
it
when
is.
it's not me.
You better have a knife before drinking that whiskey, Nick. That's no knife. This is a knife.
Careful. Does YouTube censor that?
No, they haven't so far.
Oh, okay. Well, Sean always has like a plastic QP.
Oh, by the way, were you here when I talked about because Drunk Me bought me this little knife with apparently with a flashlight on it.
Very cool.
Now, of course, as speculations go. Let's make it bigger. So we talked about the machete, where somehow I will have a mag light on a machete, because why do something half done? Now, Maglite might have objections of having their name used in that. So I might use a non-brand flashlight. By the way, machete is not copyright claim, or trademarked. Cheers. So no, not going to hide my knives. I'm going to improve them.
If it's worth doing, it's worth overdoing.
Sold near a hillbilly Florida man and the Clinton family near you.
And so now I'm worried that you need to check your brakes before you go to work.
A machete light, or machete. The Nick Light Max. Oh, I like that. Thank you, Matthew. Timu Light. Yeah, I'm sure it's already been sold on Timu. They steal all the good ideas.
Stand to be corrected, but certainly this is the explanation that might sound most favorable for the defendant. But what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully, former trooper Proctor, and Sergeant Yuri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's Office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We talked about my voluntary withdrawal from the indictments concerning Mr. Kearney. And if Your Honor would take a look at page 6, where we have bullet points. All right, the first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Mr. Kearney. And we hear that Lieutenant Tully is being sued by Mr. Kearney. So what? That Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say?
Everything, because I mean, that's a different civil suit. That Karen Reed, for obvious reasons, are suing the alleged killers who tried to set her up. That has nothing to do with you. Sure, but it's still within the realm that you voluntarily or involuntarily, by aiding Gaetani, McCabe, and the others in prosecuting Aidan for revealing what might have actually gone on in the house.
There were disciplinary proceedings against Lieutenant Tully.
Might be relevant on cross, you agree?
Yeah, they might have some relevance on cross, but what has it to do with disqualifying me? They weren't disciplinary proceedings against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed. What has it to do to disqualifying me in this case? We hear that Buchanan was disciplined. Proctor has been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. Gattani's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. Well, let's look specifically, if I can skip ahead in the memorandum.
I'm playing in 1.5 and it's
The
still
argument
slow.
that's been made a little later on
It
in
would
the
be very painful to be sitting in that
heard
courtroom.
again today.
Sorry?
It would be very painful sitting in that courtroom.
Yeah.
And I'm looking now at page 16, Your Honor, the first full paragraph. Ms. Gattani will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and/or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted.
Yeah. For those who don't know, when the defense compared Tully's and Gaetani's phone, they discovered that Gaetani had way much back and forth than Tully had, and Tully handed it over as not being tampered with at all, and still it lacked a lot of information. But of course, it must have been a glitch in the system, because cops never do anything wrong.
Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. Now let's put this on a timeline. It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone, and their explanation is that must be because Detective Lieutenant Tully deleted it.
That would be
I
the obvious
responded.
answer.
Ms. Gattani is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position.
She's a late bloomer to the discussion, but the information she has are years old. It doesn't really matter when she showed up. It's the information she's bringing. Right?
Well, yeah, I mean, he's basically trying to make the argument that what she's saying is irrelevant because why wasn't this all brought forward earlier or anything like that? Well, it's a superfluous argument. She still has vital information, and when she came across it or when she became aware of it is completely irrelevant to the case.
Yeah, I mean, let's say that Cosgrove was prosecuting a murder case, and the defense said, well, this witness didn't show up until 2 years later. So? I mean,
Suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate,
if her phone shows different things than his phone, something is wrong. Are you, Mr. Cosgrove, are you saying that the download itself might have deleted things? I'm sure defense attorneys in your previous cases would love to hear more about that. Seriously.
My response as to what happened to the cell phone occurred before Ms. Gattani made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points. I want to turn to the legal argument, say a little bit about the law, and I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named USB Health, which involves a complicated civil action involving the Church of Scientology and others.
What? Church of Scientology is involved? Let me back up here a bit.
The other case is named USB Health, which involves a complicated civil action involving the Church of Scientology.
Oh,
and others.
okay, they're citing case law. Okay.
The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So at best, I would say they are persuasive authority, not private authority.
I don't think Ms. Betterow contests that.
No, of course. The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap, the decision of the Superior Court judge was affirmed by an equally divided court. The dissenting justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Gattani in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at USB Health, I guess it is, which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the insights, but I think Your Honor will readily find them. The defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating Scientology's constitutional laws. We can look back at the memos filed by the defense, and the contention they're trying to make, well, one of them is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors made at the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occurred before any involvement by Ms. Gattani, before any involvement by that man with me. And those issues are pretty well set and they have consistently been followed through. And there's another similarity between height and the current case. I'll just read a sentence or two.
Have he actually said something? I mean, he has a lot of words. But for the past 15 minutes, has he actually said something?
Nope. Nothing that would have any relevance as to why he shouldn't recuse himself from the case.
Absolutely nothing. Now, I saw that Hella has to go, but before she does, I think we should watch.
Look at Dolly's face. He's like, it's such a menace.
Here is what happened at Judge Simpson's court.
Hi, can you hear me?
Yeah, we can hear you.
Okay, Jessica Bruscella.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's going to need to, let me just stop you. She's going to need to appear in person. We've had a problem with this defendant. We've kicked her out of our courtroom. I think on 2 occasions she's come back in. She was smoking.
That wasn't me.
Go over there and don't test.
I can go test. I can either pan out or just make that money up. But I can.
That wasn't me.
I'll grant the motion for. Thank you. Folks, my staff has reported that was you. And
No,
it appeared as though you were having sex on the screen.
No.
I believe she understands them and at this time knowingly voluntarily waived them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about
Well, that's it. Oh, that's a handy.
yourself be God?
That's a handy dandy.
I mean, this is court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine.
Whoa! Oh,
That's yeah. You see
Oh.
the shakes.
She's
Yeah.
no longer using her hands.
Yep.
On your honor, for the record, Brian Stacy P 33014.
1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
what the fuck?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on
Yes,
your behalf?
yep, yes, Your Honor, yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes,
And amphetamine in your possession?
yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using as methamphetamine?
Yes, I did, Your Honor.
Ma'am, if I accept
Right,
your
girl.
plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea.
The
of guilty
defense
to
are
count 2.
satisfied.
Count
Yeah,
1
sure.
is dismissed.
At least somebody was.
Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for
This happened live. on
February 11th,
Discord.
2026, 9 a.m. That's before.
Like I saw it.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, there's. Well, go ahead, Counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail she's been in jail since January 8th.
Yeah, look a shame.
And she
I know
also,
that
Judge,
one.
has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently, she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention.
Speaking of kidney stones.
Well, it
Kidney
was
shifter
interesting.
there.
The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am. That way we can assure you're not smoking and not having sex while you're in court. Thank you, Yvonne. We'll continue.
Thanks. Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my face.
They don't show it here, but when the court reporter goes and tells Judge Simpson, he kind of just looks at her and just starts smirking and then takes a break to go watch it.
Oh,
but you started laughing.
Wow.
She's really drugged up, hey? Like, she's really drugged up.
I mean, if she doesn't use this to start an OnlyFans career, she's missing a huge opportunity.
Oh my God, he does smirk. That's hilarious.
Who would want to see anything below there on that woman? Like,
Yeah, I'm glad we didn't see all of it.
God, like, yeah, there was zero foreplay.
No.
It was.
I mean, she used her hands a little to start.
I guess.
She
We didn't see her.
She gave oral
one hand.
argument.
She did give it oral. Well, wasn't very convincing. But yeah, she did not raise her hand. Actually, no. She was not the one being.
No, they were
Someone
talking about
else.
another case while she was performing.
Yeah, well, I mean, like.
Yeah, she
I
was
guess-
there for like an hour,
Well,
waiting for her case to be
getting
called.
bored.
Exactly. I mean, she was there, and just on camera the whole time. And then after
Well,
a while, she got bored. And
Well, lucky she didn't light up a crack pipe.
I know that's happened
That could have
before.
happened.
So
She was fucked up.
Wow.
She was a mess. Like that her face. God. Gross. Ugh.
Now,
Yeah.
how
Man,
am
you'll
I
appear
supposed
flush. Do we need to call an
this for
ambulance?
YouTube?
Ugh. Yucky. Gross. See, this is the outcome of the COVID era,
Come.
right? Sorry. Yeah. Oh, by the way, it's 5 years since the lawyer cat.
yes,
Yeah.
Oh,
5
yeah.
years.
Yeah.
Wow.
It's the 5-year anniversary of lawyer cat. Yeah. Yeah. I'm not a cat. I still want to go forward, but I'm not a cat. But this is what's happened. Like as a result, like I like the fact that you don't have to go places and you can have meetings. But unfortunately, what you've got as a result is people not taking important things like going to court seriously.
Yeah,
And
in
then-
this case,
No.
it seems like more like a fetish.
I kind
I
of feel
think
like
so.
the way that they did that
The way-
seemed like it was premeditated. Like I feel like
Yeah.
they thought about what they were going to do. They planned it
Yeah.
out.
she
They-
could have just
Yeah.
turned her camera off until her case was
And
called.
Yeah.
they knew they were on Judge Simpson. They knew it was going to go out live.
Yeah, sometimes people do it. Sometimes people like go onto the court streams and fuck around on purpose. And I didn't
Yeah.
like she actually did fuck around. Hey David, how are you? Two Australians existing on stream together. Yeah, we're trying not to get arrested
Yeah,
because
trying
if we
very
insult
hard.
one another or if we say something insulting, both of us could end up locked up.
Wow.
Could absolutely happen. All right, I have to run. Thank you
Thank you.
for having us. Nice to see you, Hayden.
Yeah, you too.
Try to stay out of jail.
I will. You too.
Do your best. Okay.
See
See you.
ya.
No promises.
Bye.
Bye.
Oh, I got to get going too.
Aw.
I'm sorry, man. But thanks. This
No,
was
no
a lot of
worries.
fun.
No, I should have known you were only here for the peen.
I mean, not only, it just 50-50. I enjoyed seeing you as well.
Yeah, thank you. Thank you.
And nice seeing you, Ozzy. I'll see you guys later.
Yeah, bye. Oh.
There you go. As soon as David points out there's two Aussies on stream, one of us has to disappear. It's an imaginary fallacy. As soon as someone points it out, poof.
Mm. Oh, all right.
We can do it.
We can do it. We have. Oh, we.
The government contends that prosecutors cannot
1.5
be
speed, folks.
disqualified when sued by a defendant, because defendants could then remove whichever prosecutor they please simply by suing him.
Wait,
And of course-
hang on. Stop it.
No, yeah.
Anyone could simply remove the prosecution simply by suing them. Well, I mean, if it's a frivolous or vexatious case, it's going to get thrown out if there's no merits to it. But if there's genuine merit to it, yes, they probably should be thrown off any case where the prosecutor's sued.
Yeah. And Mr. Cosgrove, you didn't file a motion of frivolously. This has not. No, you had to file about immunity.
Which means that there is bones to the case, which means he should absolutely be recusing himself.
Yeah.
Why is he hanging on like a dog? I don't get it.
Because I would assume it is because of the Karen Reed civil suit, and they are still trying to get Karen and Aidan in there for witness tampering together, even though it's been dismissed by a grand jury, and grand juries indict everything.
The defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court.
In the middle of everything, I saw this. Thank you, mispronounced name, for gifting 10 memberships. Thank you so much. Thank you. It went to Gwen Wildcats, Tracy Burton, Toffee Sock, TN Oncology, Nada Stole the Spoon, Jennifer Thomas, Tushinko, John Sebastian, K. Ray, and Richless. Thank you so much for the gift of memberships. That brings us within $20 to the next spin on the Wheel of Regrets. Thank you. That is so nice of you. So nice.
Tell you what, it's close enough to 11 now as well. So if you manage it, people, I'll chuck it back a meat as well.
That I cannot be disqualified.
It's 11 a.m. somewhere.
When sued by a defendant or by Ms. Gattani. I think in fairness, the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in a prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, you will find that the court in Height pretty much brought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution.
and nothing in this prosecution is going to affect anything that's going on in Middlesex. I'm sorry, yeah, what's just occurred at court, Your Honor.
Any further? From Mr. Cosgrove.
No, I'll stop at that.
Mr. Becker.
Yes, thank you. We might as well start from the back with US v. Health, Your Honor, which is 668 Federal 2nd, 1238, DC Circuit 1981. Mr. Cosgrove has buried the lead about Health and about Dunlop. Those were appellate arguments post-conviction. Now, that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal, when you could have raised it before, is looked at in an entirely different way. And the relevant language from Health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words there are allegedly bad faith. And I'm not sure that there's an allegation of those other things. Bad faith is an allegation he violated the statute.
She
I'm
had
not sure where he talks about
She
that.
sued him for intentional infliction of emotional distress, coercion.
Negligent infliction, there's a difference.
She sued for intentional.
Negligent, but
I respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but that's, the court can obviously go back and one of us.
We do traditional.
Exactly. One of us is right.
I read this one as intention.
Dunlop is the same situation, Your Honor. It's post-conviction. The other issue, and I want to go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome. But he's justifying it and saying she's trying to do this, she's not credible. The point is this. The personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. If this looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, is literally aligned with Jennifer McCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation. No, but the point is this. He is looking at this in a vacuum. The public must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae.
Let me slow down, because we're conflating two different issues. I'll agree with you. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, was a late comer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing.
I didn't think that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing that I'm dealing with is this one issue. Because the rest of those things he had nothing to do with.
Well, the one of them, he had his other conflict, which he voluntarily sought.
But that came out of the same exact issue.
Yes. Well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw, the distinction is, all of these other problems that arose out of the Reed prosecution, really imagined substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all those
The
problems.
difference, the difference is that if it's not Mr. Cosgrove, the man or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL Tully.
That's my point. That's the only thing I have to analyze.
Okay.
That point.
Our point respectfully was that given the public's need for confidence, in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think.
LMP, for fuck's sake, can this judge shut up long enough to allow Mr. Barrow to finish an argument? No. Apparently not. Apparently not. Thank you so much, LMP. Thank you so much. And that gets us within $10 of the next Wheel of Regrets. Thank you so much. Thank you.
I think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even committing to calling Ms. Gaetani. I can't fathom how that might happen. They used careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial, and there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance? I'm calling this witness. We're alerting Mr. Cosgrove to what we think is his conflict in the court, and we may very well do that. The last point for this, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, tampering with her phone. The best basis for that will be the posting online social media by a third party and longtime known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Fair enough. All right, so here's what we'll do. We'll set another date. Let me talk about Mr. Brady, we selected the penciled trial date. I gave you a very long date, longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive? We're not moving the case back. That trial date's not going to go backwards.
Okay.
This is a 2023 case, it's 2026. It's not going backwards. If anything, it's going to move forward. So don't.
I know you'll relate to this, Judge. I have the usual slate of fall murder cases.
I get it. This one's an old one, and it's set. So I was going to try to move you forward, but if you tell me that can't happen, that can't happen.
I'm sorry.
All right, understood. This court is willing to take this case much faster than the current schedule.
We do have a few other pre-trial matters to discuss. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're going to do is this. I'm going to take this under advisement. We're going to pick a date right now. And either we do a motion to dismiss that date, or we're on for appearance of new counsel that day. Right? One or the other. We're going to know. I'll get your decision before. Now, I'm open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine. I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But even if counsel stays on the case but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case, and the jury ought to know of that interest.
Mr. Brady, you and I both know this happens with some frequency, and we work our way around it. All right. The jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect it to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point that there's been some recent cases talking about the police can't create their own exigency. And to some extent, the defendant has created his own exigency here, because in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you got to be fair.
In all honesty, it's more than putting her phone's content on the internet. In my opinion. Yeah, he just said Cosgrove raised an argument. I don't think that's correct. Because that's not the only thing Lindsay is suing them for.
Both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of response to that to be perceived as a acknowledgement. I don't want to address that.
I'm basing it simply when I read her complaint.
Sure.
Not anything's been represented me today.
Right, exactly. And so just a couple rewinds here, judges, that the government themselves, in Lieutenant Tully's own affidavit at the time of this, back in December of 23, swore in the affidavit that Ms. Gattani was a witness. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Well, she's a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed.
Right.
And,
but apparently it's still alive and under investigation.
Well, that's another matter. I told you I have no authority to affect that. What I do know is that was no prost. Not no prost. No bill. Even worse. Okay. That was no bill. So I can't imagine a circumstance where I would allow evidence in about a no bill issue. I remain to be persuaded on that.
So what? And just to go to the lowest hanging fruit and why Ms. Gattani would be a witness, there's all sorts of screenshots and text messages. You know, we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons.
I get that,
but no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that the closing argument is going to change that, because the closing argument is based on what's heard at the trial, and I'd add, in this court's view, in the proper practice, be confined strictly to the evidence that's presented before the court. So,
I appreciate your reflection, Judge. If I could just have one moment. Thank you very much. That's all we have. And just
let's pick a date.
Are you late February, March? Okay, early March. What would you like, Mark?
Let's go later in March.
March 27th.
Is that Friday? Friday's generally best.
It is a Friday.
Do it on Friday. Someone will leave this room. I'll have to consult with the document.
All right, so they are reconvening late March. Jesus. This is one of these cases where it has to be Cosgrove because he's paid to prosecute this case. Now, he was a special prosecutor in the other cases as well. This is the last one. Maybe, I don't know. Maybe he just wants another payday because every time he shows up for court, it's a payday. Jesus. This is a 2023 case. Now it's 2026. They're reconvening in March. Trial is not until this fall. And it all depends on Cosgrove being a prosecutor. If he's not, this will fall apart. And I believe the case in the criminal case, which they are desperately trying to get again with witness intimidation against Ken Reed and Aidan, also depends on how this case is going. So they have to keep it going. But then again, Morrissey is retiring. There's an election this fall, and somebody else will take his place. And once that happens, this will probably go away. Because the person aiming for DA is Mr. What's his face? Let's see if I can find it again. I spoke about it earlier. Well, it is the person looking for the DA's office is one of the agents who investigated via the FBI or DOJ about the all the fuck ups in the DA's office and in the Canton PD and the Boston PD. Mr. Deitch, I want to say. Mr. Deitch. So if he wins the election, gets appointed. Yeah, thank you, LMP. Adam Deitch. Yeah. If he wins, all of this goes away. Because the DA's office will no longer go for this case. So it's kind of in... now, of course, the defense here, Mr. Bedrow and Mr. Bradle, yeah, of course, they want it dismissed and Cosgrove thrown out as soon as possible. But if they wait and Mr. Deitch takes office, it will go away anyway. Whew. What a clusterfuck. No. Is your microphone dead? So you've been sitting there listening and oh, all right, folks. We're almost 3 hours in. Hey, we are $10 away from the next spin on the Wheel of Regrets. I will give you guys a discount. I will give you guys a discount because we're almost 3 hours in. And so, Wheel of Regrets. It's the Wheel of Regrets! Canadian whiskey! Which means the premiere of this. Screw cork on a plastic bottle. What? Oh, it's one of these corks that stays on. All right. All right. Mispronounced name. Welcome to Canada. All right, folks. Everybody, thank you for joining. Thank you for listening in. Thank you to Aidan, to Hella, to Dali for the interesting development in Judge Simpson's court. Thank you, guys. Thank you for sponsoring the opportunity for me to, in the next 10 years, maybe retiring to the United States. Now, usually this is on Fridays. I had to choose Saturday because I had a power out because of a winter storm, but it went okay. Folks, I will see you all in the next stream or video. Thank you. Cheers. Oh, that's bad. What the fuck? What? Oh. What the fuck is that? What the fuck? No! No, it's on my Wheel of Regrets. No!
From distant lands we gather,